Hello, my name is Chad Graham from the immigration law firm of Graham Adair. Today I will be covering an update on USCIS expedite requests based on a policy manual update that was just posted. Our YouTube channel covers immigration news and updates, so be sure to click the subscribe link below this video so that you can be notified when we post breaking content. Now for the update. USCIS considers all expedite requests on a case-by-case basis and generally requires documentation to support such requests. The decision to expedite is within the sole discretion of USCIS. As expediting an application, petition, request, appeal, or motion generally means that USCIS would adjudicate the requester's benefit ahead of others who filed earlier, they carefully weigh the urgency and merit of each expedite request. USCIS considers the totality of the circumstances and evidence submitted in support of an expedite request. The totality of the circumstances test means that decisions are based on all available information rather than bright-line rules. Under the totality of the circumstances test, adjudicators focus on all the circumstances of a particular case rather than any one factor. A really interesting update involves the processing for submitting expedite requests. Most expedite requests can be submitted by contacting the USCIS Contact Center or by asking USCIS's chatbot called Emma. You can access Emma by clicking on the Ask Emma icon on the top right of a USCIS webpage. Requests must explain why expedited processing is needed. The request will need to provide a relevant receipt number so that they can send the request to the office that has the application or petition. Requests must also provide supporting documentation. One of the biggest changes in this policy manual update is in relation to clear USCIS error. USCIS may expedite in cases where a requester establishes an urgent need to correct the error. For example, an applicant who receives an employment authorization document, also known as an EAD card, with incorrect information that prevents them from being able to work, may request a replacement document on an expedited basis if USCIS caused the error. There was also an update to the process for requesting expediting of advanced parole, which often applies to people who have filed their I-485 application for adjustment of status. Circumstances under which such individuals can request an expedite include the need to receive medical treatment in a limited amount of time, or the death or grave illness of a family member or close friend. This policy update also now allows expedite requests for planned events, so long as the person applied for their travel document in a timely manner, but current USCIS processing times will not allow the person to receive their travel document in time. This includes work and academic-related events, as well as certain personal events such as a wedding or graduation. It does not include the desire to travel for vacation. Although this is not new, I want to provide a reminder that the primary category under which most expedite requests are submitted is the severe financial loss to a company or individual category. The need to obtain employment authorization by itself is not sufficient. There must be documented evidence that the company stands to suffer significant financial loss, such as losing a major contract if the case is not expedited. As for individual loss, this can be proven by showing loss of access to important public benefits or services, such as housing, like the termination of a rental agreement, or health insurance or education for children, and these are just a few examples. Thanks for tuning in. If you're a subscriber, we'll see you on the next breaking news update. If you're not a subscriber, let's change that now. We'll see you next time.